Namaskar. My name is Abhey Kumar and I am one of the members in the faculty at Vajiram and Ravi to discuss Indian polity, which is part of the syllabus in General Studies, paper 2 of Mains and also in the Prelims. So in today's video, we are going to discuss the idea, a fundamental concept in our subject, that is the procedure established by law and the due process of law. Now, one point that we must be clear, what does it mean and how they are different from each other? In fact, in the background of some recent developments in our country, where all of us witnessed the protest by Cockroach Janata Party in Delhi, Jantar Mantar in the central Delhi area, and one of the incidents that took the highlight is the excesses done by the police. For example, nail-studded lathis being used during the lathi charge, and the courts also have observed, and all of us as citizens of this country feel, and the court definitely has also observed, that this is not according to the SOP, the standard operating procedures of the Delhi police. Which means the executive, which is the police in this case, they have not followed the approved procedures. Casually you can think law. So that means it is wrong because it is not as per the procedure that has been defined. A question arises, what if the procedure had allowed? Imagine the SOP says we can use nail-studded lathis also. Would that justify the use of such kind of weapons and such kind of instruments? The answer of that lies in this distinction between procedure established by law and the due process of law. Now, the root of this actually comes in Article 21 of our Constitution, which provides for the protection of life and personal liberty, and it simply states that no person shall be deprived of life or personal liberty except according to the procedure established by law. So what definitely is written as chosen by the members of our Constituent Assembly is the procedure established by law and not due process of law. And that is why this has been an aspect of long drawn debates in our judiciary as to what is the real meaning of this phrase. So let us understand both these strands one by one. Firstly, the procedure established by law. So this concept emerged under the English constitutional scheme. So it's a British concept, and the essence of this idea is simply follow the law. Whatever the law prescribes, follow that. As long as that is happening, we are following the procedure established in the law, so the action would be considered a correct action. Now, there's one more thing we should know here, that though it originated in the English system under the English Constitution, however, when our Constituent Assembly wrote these provisions, the language has actually been borrowed from the Constitution of Japan, and specifically Article 31 of Japanese Constitution. So Article 21 of Indian Constitution, Article 31 of Japanese Constitution, and I've put in quotes here for you. Very similar to what we have written also. No person shall be deprived of life or liberty, nor shall any other criminal penalty be imposed except according to procedure established by law. So this again sometimes comes in the discourse, that where has this idea been borrowed from? So it's borrowed actually from Japan, but the legacy is, British legacy. So this is some basics. Then moving forward, what happens in this system is that when some individual's life or liberty has been deprived by the executive, let's say the police has made some arrest or has done something to deprive the life or liberty, then in judicial review, the judiciary has got limited powers. They can do only a review to a certain extent, which essentially is defined by three fundamental things to be understood. Understand, procedure established by law means any procedure that the executive has followed which was mentioned in the law. Okay. So first thing, there should be a law. So the first question that the judiciary examines, whether there is a law that has authorized the executive to deprive the individual of their life or liberty. So is there a law? Okay. If there is no law, then executive cannot do this. There itself, the action of the executive will be declared invalid. If there is a law, then comes the second question, that whether the legislature which enacted this law, they had the competence to enact that law. Are they competent enough? Are they authorized to make such a law? For example, in our constitution, all of us know there is this seventh schedule, union list, state list, concurrent list. So the competency has been defined that who can make law on what kind of subjects. So whoever made this law, do they have this competence to make that law? For example, Indian laws only will apply in India. American laws have no significance here. So we cannot say that under American law we are doing this, just as an extreme example. If a competent legislature made this law, then it is fine. But then there is a third question also, that when the legislature made these laws, did they follow the prescribed procedure? Okay. So, for example, Parliament made some law, and while making the law, they have followed the procedure. What is the procedure to make law? All of us know that it has to be first introduced in the form of a bill in one of the houses. Depending on different types of bills, there are different houses. That's not our topic right now. So they introduced it in one house by discussion, etc. As per the procedure, whatever majority was required, it was passed. Then it went to the second house. It went through the procedure, voting. Then it took assent of the President of India. And then it was notified in the Gazette for it to be enforced. So did they follow the complete procedures or not, right? If the court finds that there is a law made by the competent legislature and the competent legislature has gone through the entire process of making the law, then whatever the executive has done under that law, that is correct. That is why if there is a law, the law was made properly, the law gives the authority to the executive and they can deprive. Now, obviously, when this kind of a thing is happening, nowhere we are questioning what about the law itself. Is the law a good law? Otherwise, any random thing can also be written in the law. We can write in the law that, such kind of weapons, nail-studded lathis can also be used. We can break the head of the person also. It will not be good law. But in this system, because that's how it has evolved, there is no such question will be examined by the judiciary with respect to the legislative action. That's why we say it is a limited power. So, if you have understood that, it's very obvious now that in this system, courts can extend protection only against the arbitrary action of the executive. That did the police follow the law or not? There is no protection against the legislature's arbitrariness. That did the law itself, provide for goodness or the right kind of tools, etc. So there is no protection against legislative action. So obviously you can understand why this system came in UK also, because UK has parliamentary supremacy. That's how their systems have evolved. So this concept relies largely on the good sense of the legislature. This kind of a trust that the legislature will make a good law. And obviously the strength of the public opinion, that even if something wrong has happened, with the strength of the public opinion, accordingly the law will get modified or corrective action will be taken. So it relies after certain point on the goodness of the legislature and also the strength of the public opinion, the democratic spirit of that country. And hence, it was very obvious that these kind of things emerged from the British system. However, on the other hand, if you see the due process of law, fundamentals of this first, it originated under the Constitution of the United States, the US Constitution. And in essence, as the title also tells you, due process of the law. So when the law is fulfilling a purpose, there is a reason why the law was made. Due process means the entire process of lawmaking, starting from the very intent behind the law, the essence of the law, the spirit of the law, the goodness of the law. That also has to be then examined in due process of law. So that is why this gives wider jurisdiction during the judicial review when an individual's life or liberty has been deprived. Judiciary goes beyond what we have already seen in procedure established by law, where we checked did there exist any law, and was it made by a competent legislature, and did the legislature follow the procedure. So we will discuss all of that, but we'll go a step further and we will also test the goodness of the law. That is the law a good law also? Is it a fair, just, reasonable law? Is the law, the intention behind the law, a good thing? So in that way, it can provide protection against the legislature's action also. Not only the executive but also the legislature has to satisfy these conditions of fairness and goodness. So, how do we check the goodness of the law, the fairness of the law? And that is where there is a test of non-arbitrariness. I believe from your wider studies, you know that that is the principles of natural justice. So, for something to be not arbitrary, fair, just, reasonable, principles of natural justice to be followed. Now, we are not going to go in detail in this video about natural justice, but still, since we mentioned, there are three principles of natural justice that we believe in our system are required. First is audio ultrum partem. That's a Latin phrase which simply means listen to the other party. Simply saying right of hearing, right to a fair trial. The court also said, no, for example, the DCP who was seen slapping the girl, Mr. Lamba, that just because there is a video, we should not, just make our judgment on this. He also deserves a fair trial. So the court basically saying that we will listen to his side of the story also first before we make a comment. That's what we're saying. It's natural justice, It's natural to any authority who's taking some call that listen to the other side also. Similarly, nemo judex in causa sua, which means no person to be a judge of their own cause. You cannot decide your own case. And that is what happens in judiciary also. You may have seen that the judges recuse or should recuse from a case where they may have direct, indirect interest involved in the outcome of the case. And a general idea that every authority shall act bona fide. That is, they should not be arbitrary, they should be fair, just, reasonable, they should be transparent, they should not be oppressive, and they should always act in public interest. That should be driving them. So essentially we are saying the legislature should also satisfy this idea of acting in good faith, acting non-arbitrarily in a fair and just manner. So if the court finds that the legislature's action is unfair, it is unjust, it is unreasonable, it is fanciful, then they will declare that law also as invalid. Whereas in procedure established by law, there was no test. So in procedure established by law, technically speaking, no matter how oppressive the law is, courts cannot declare that law as invalid. Whereas in due process of law, they can. So, in the landmark case of Menaka Gandhi versus Union of India 1978, the Supreme Court of India, 7 judges bench, 7-0, unanimous judgment, they held that principle of natural justice is inherent under Article 21 of the Constitution. That is to say, where it says that a person can be deprived of life and liberty by a procedure established by law. The spirit of our Constitution is that law should be good law. Okay? It should be a fair law. And the moment we talk about fairness and non-arbitrariness and justness, we are talking about natural justice. And hence, the court concluded that while procedure established by law is written in the text, the spirit of the Constitution requires that we follow due process of law in our Constitution. So, for the last 50 years roughly, since this judgment, there is no difference in our system, in our country's system, in our governance methods between procedure established by law and due process of law. I also would make you think about one aspect that all of us know Dandi March. So, Dandi March was basically against the salt law, Namak Kanun, which the Britishers had made, where they were not allowing common people to make salt from seawater essentially, which Gandhi said that this is a bad law, this is the most essential need of our life to have salt. And he said, I will break the law. So you can think that if there is a law saying that you cannot make salt, we should follow it. Whereas he said, no, the law itself is bad. So essentially what he's thinking in his mind, he was thinking at that time, is the principle, what we are saying, due process of law. Now, that's all that I wanted to discuss. I will leave you with a question that came in the civil service exam prelims of the year 2023. And this is exactly that question, that in essence, at the core basically of the due process of law, what is there? So some options are given. I'm sure you can answer, not because you know the answer key already, because you are able to understand, and you can write in the comments what you think is correct, and you'll see majority how they feel. Answer key is already known, so I don't have to tell you the answer, right? So on that note, thank you very much for listening to this video, and I wish you all the very best in your journey to clear this exam and enter the system of governance of our country, and you start serving the people of India and humanity at large. Thank you very much. Jai Hind.